Welcome to Crime News with Mark Solomon. Today we're going to be talking about the state's filings. Just happened yesterday. They filed opposition to the defense's motion for a new trial with a long brief. We're going to talk about that. But before we get to that, don't forget to click like and subscribe. If you're enjoying these videos, click the bell to be notified of future videos so when I upload new ones, you will know about it. So let's go ahead and look at the filings in that case. If you look, you can see on the state page that they've put in the court system, they have listed all of the filings in the case. And we're going back a little bit, but when we look at the June 2nd, that was the defense's filings to ask for what we call in Colorado a post-conviction motion. Basically, right after the trial, but before sentencing, the defense has to ask for a whole lot of things so that the trial court can address fairness of trial, what the judge did wrong, and allow the judge to address that, make a record, and obviously that's going to be appealable by either side. But June 2nd is when the sentencing memorandum and the post-verdict memorandum, plus the state's memorandum law and sentencing, all that was filed. Now, yesterday, June 16, here you can see the state filed a memorandum in opposition to the defense's post-verdict motions. Let's look at that, because that's going to tell a lot about what the defense did and what the state is saying in response to that. So here you can see this was filed just yesterday, June 16, and it is the state's memo in opposition to the post-verdict motions. I'm going to skip a little of the intro. I've highlighted some so we can get right to the meat of the arguments. The defendant's motion for a new trial should be denied. Well, it's not based on pretrial publicity, says the prosecutor. And I've highlighted some passages here. He did receive a fair trial by an impartial jury, and nothing requires the court to take the extraordinary step of overturning the jury's lawful verdict. Let's unpack that for a minute. When the state says that there's an extraordinary step of overturning the jury. Think about that for a second. We have a system of justice where a jury hears the case and makes the factual decision, did he do it or not? And in this case, we had a jury and they made a decision that he did it. That's the guilty verdict. And when the court says, well, we don't think this is working for some reason or other, and they go back and either award a new trial or overturn the verdict altogether, that's what we in the justice system call an extraordinary step, because the whole system is designed to give the jury the power so that the courts aren't making the decisions of whether or not somebody committed a crime. It's a jury. What these entire sets of motions and responses and replies to motions are all about are trying to figure out whether or not that was a fair verdict. Whether you had an opinion on that or another, let me know in the comments. I'd love to hear it. We'll talk about it in an upcoming episode. But in this case, the state is saying that the defendant requests the extraordinary remedy of a new trial after a verdict, and he bears a heavy burden. He must prove that both the court abused his discretion and that the court's decisions actually prejudiced his case, which is really difficult to prove. The prosecutor goes on and talks about how, or wrote about how, the court properly exercised its discretion to decide where, when it held its trial. The case is of international prominence. There's no reason to believe that any part of the state was less impacted by any of the pretrial publicity. And he goes on to say that, very importantly, this court's decisions did not prejudice the defendant in any way. He received a trial by 12 impartial jurors, and I know there's some consternation about that, all of whom testified that they could try this case fairly. There was no accident. The court oversaw extensive voir dire process, and we all saw the extensive voir dire process. So that's, obviously not in fact. The real question is, were they impartial? And we're going to get to that later down in the in this response. Now, I've highlighted in red. It came out a little bit hard to read, so I'm just going to read it to you. It says, the defendant has offered no concrete evidence to the contrary. Instead, he asked the court to presume that the jurors were prejudiced simply because this was a high-profile matter. You should read this because he talks quite a bit about how the defendant was not denied the judicial serenity and calm to which he was entitled. He talks about how this was not a kangaroo court. There were no, outrageous shenanigans going on in the courtroom, and that this was essentially a fair trial. Now, one of the other questions that keeps coming up is whether or not this should have been tried in the county where it was tried, or whether it should have been tried in a different venue. Now, I always tell people trying to win on a venue issue is really hard. It's usually a losing argument. Here in Colorado, you either object to it and give notice many weeks before trial, or you've waived the argument. In most cases, objecting to the venue just moves your trial to a different place. And in this particular case, the prosecutor saying that moving it to a different county in Minnesota wouldn't have changed the outcome, because everybody in Minnesota and pretty much everybody in the United States was looking at this case. And so moving it to a different venue wouldn't have changed a thing. So I'm going to move on to the actual reasons why he said this. He said he has not met his burden to establish that the court erred in holding a trial in Hennepin County, and he says there's 4 really good reasons. First, prospective jurors can be presumed cannot be presumed partial solely on the basis of exposure to pretrial publicity. You have to prove actual prejudice. Second, the Minnesota Supreme Court repeatedly affirmed district court's denial of a change of venue, whereas here the pretrial coverage has affected the entire state. As I was saying, it affected the entire country. Third, the court properly exercised its sound discretion to try the case in Hennepin County by exposing extensive procedures to safeguard the defendant's right to a fair trial. And they talked about, the jury questionnaires, the extensive voir dire, and all of the questions that went into picking these particular jurors in the case. Fourth, in its November order denying a request for venue change, the court also properly determined that it could better ensure the safety of the trial participants in the Hennepin County Government Center. As in moving them to another county, that court couldn't guarantee that moving them back and forth from home to the county where the trial might have been held was actually safe for the witnesses and so forth. And because of that, prosecutor goes on to state a legal standard for which has to be met. The defendant must show that the jurors who tried this case were actually prejudiced by publicity. And here, he has not and cannot meet his burden to establish actual prejudice. Remember, these are arguments by the prosecutor. Each juror here was carefully vetted in voir dire and affirmed in his or her impartiality under oath. The defendant offers no evidence to the contrary. But again, there can be arguments made and inferences made, and that's up to a judge to make that ultimate decision. And here, none of the defendant's counter arguments are remotely convincing. Little bit of extreme argument there, but let's keep going. Let's actually move on. There's a lot of argument. If you can see from the bar at the top, this is a very long brief, and I'm not going over all of it. I'm going over the parts I thought you'd find most interesting. The court did not err in declining to fully sequester the jury. There's some good back and forth on this channel in the comments about whether or not sequestering the jury before deliberation would be a good issue for appeal. And clearly, this is one they are actively litigating here at the post-conviction part, but before sentencing. So the court was well within its discretion to decline to fully sequester a jury and instead preserve jury anonymity, admonish jurors who avoid media, and sequester the jury overnight during deliberations. And he talks about this, and he gives reasons. First, the defendant acknowledges and the court repeatedly admonished jurors to avoid news. Whether they did or not is another question. The court's anonymity order and instructions to avoid discussing the case with anybody was designed to protect the jurors from harassment, which is, again, an outside influence on the jury that would have affected their verdict. Absolutely. Finally, the defendant again fails to offer any evidence that he was prejudiced by the court's decision. And again, he's making the assumption that something could have happened, but he's not actually presenting any evidence that it did happen. And that's a common theme in defense prosecution arguments. So then he moves on to another huge topic, which is whether or not the prosecutor in this case committed prosecutorial misconduct, which is always going to be an allegation, especially in a high-profile case like this. And I've just gone and looked at a few. Like, for example, the court already rejected the defendant's complaints about discovery. Again, discovery, always a heavily litigated issue in a trial. This is the one I wanted to focus a little bit on. There was some evidence that one of the jurors was wearing a BLM T-shirt at the trial, come to find out. And so the prosecutor is directly addressing this by saying that no slogan was visible under Mr. Williams' shirt in the courtroom, and if one was, the state was unaware. Let's stop there for a second. Remember when I was talking about whether or not perjured testimony, I'll try to put a link to the card in the video I talked about witness perjury. And I was saying that in some jurisdictions, a prosecutor has to be aware of the perjured testimony for it to be a harm, to avoid the harmless error in trial. In other words, prosecutorial misconduct would have been committed if the prosecutor knew he was presenting perjured testimony. And here he's saying sort of the same thing. And he's saying even if the BLM logo was visible, he didn't see it. He was unaware. So that's important. Let's look at these points. The defendant presents no evidence that a slogan was clearly visible underneath Mr. Williams' shirt to the participants in the courtroom. The state's counsel questioned Mr. Williams at length and did not see a Black Lives Matter T-shirt. The record suggests the court, which faced Mr. Williams and sat feet away from him, also did not notice any kind of visible slogan. All throughout the trial, the court was acutely aware of the courtroom's participants' attire, and at one point the court observed a spectator wearing shoes wearing printed message and ordered the spectator be removed. So that's pretty powerful evidence on that. And he goes on to say that the defense now claims that he was wearing a clearly visible Black Lives Matter T-shirt under his white dress shirt and did not object or otherwise raise the issue to the court, which is really important. When a defense counsel sees something, the basic tenet of objecting is if you see something that's bad, you say something right away. If something happened that's bad, you ask for relief right then, right? And that's not what happened here. So, yeah, here it is. Either counsel did not see a slogan or the counsel intentionally remained silent to preserve the issue in the event the defendant lost in trial, in which case the court should not reward his strategic sandbagging. It's a very valid point. When you see something objectionable, you have to object. And when you have an objection which is granted or sustained, you have to ask for it to be fixed right then. Otherwise, you're basically saying it's not that bad of an issue. Okay, moving on to the next issue. Dr. Baker's brief comment about a federal grand jury doesn't constitute misconduct or warrants a new trial. And this is a concept where the witness testified to references to a federal grand jury, and whether or not, and since that was the state's witness, whether or not that would be considered prosecutorial misconduct. And in this case, his argument is basically that this was in response to defense questioning, which is essentially opening the door. It's an opening the door argument, which is where you can't talk about this because it would hurt the defendant, but if the defendant elicits comments or subjects or issues that brings it up, that's called opening the door to the subject, and that means that the other side can walk through. So you can't invite error and then claim it's not fair. That's the argument here. Moving on, and I'm almost done. The state acted completely properly during closing arguments, obviously. And let's see, I think there was one more, maybe not. I'm going to leave a link to the page in the below, but I think that pretty much covers what I wanted to cover. So when you're looking at this case, when you're looking at the issues that were raised and the responses now that we have from the state, it gives you an opportunity to weigh the arguments on both sides. Whether or not you have preconceived notions of your own, you can look at the arguments and decide if you were the judge, what would you do? I'd love to hear it. Put them in the comments below. We're going to be talking about this case for a while. But for now, today's episode was about the state's response to the post-conviction motion filed by the defense back on June 3rd. They've had 3 weeks to construct this memo. It's really long. It's really well written. I can't speak to whether or not it's well researched, but it's not a difficult read. You should read it. So that was the issue for today. If you would like your own issue in future episodes, please put them in the comments below. Email me or tag me on Twitter. I will bring it up. I've got a comment I just got while this video was going on I'm going to talk about. And remember, you always have a right to remain silent. If a police officer is asking you the who, what, where, when, anything, you have a right to say, I don't want to talk to you. And if they continue, I want a lawyer. Thanks for watching. I appreciate it. I'm going to keep you updated, and as long as I'm here, you will be getting good news and good reviews, and will incorporate your comments. Thank you so much.